Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, one of the most common questions I get after we win these big lawsuits and we get rather obviously unconstitutional gun laws thrown out, the question is why can't we just sue the politicians that pass those laws and hold them civilly liable for intentionally depriving us of our constitutional rights? And the answer I always give is, well, you got to check out qualified immunity. And a lot of people have a hard time understanding how that is the great escape hatch for these politicians who, yes, I think in some cases are intentionally depriving you of your constitutional rights. We're going to show you a real life example so you can just see how the system is in fact rigged against you. So today, let's spend a few minutes and let's talk about why justice is never truly achieved in a Second Amendment case. Okay, America, we're going to talk about the scenario where you live in a state that continuously passes bad gun laws. They get challenged in court. They're struck down all the time as unconstitutional. And now you want to turn around and you want to sue the state legislators who passed that legislation because they intentionally violated your constitutional rights. Is that doable? The answer almost always is no, it's not. Why? Because of qualified immunity. So we're going to talk about qualified immunity today, and then we're going to talk about the case of National Rifle Association v. Vulo. Now, wait a second. We've talked about that case before. Isn't that the case that came out of the United States Supreme Court earlier in the year in a 9-0 decision in favor of the NRA? Yes, it is. But there is an accompanying suit against Vulo personally, and that is addressed by the Second Circuit, and it is addressed in a way that will teach you why qualified immunity is in fact the great escape hatch for all of these sorts of politicians. Now, what exactly is qualified immunity? Well, qualified immunity is a legal doctrine that shields government officials from liability in civil lawsuits unless their conduct violates clearly established statutory or constitutional rights and there is no existing case law directly on point. This protection is not absolute and can be overcome if the violation was clearly established at the time of the incident. Translation, you have to act in an incredibly malicious manner, and it has to be obvious to everyone, including yourself, that you knew you were trampling on constitutional rights. Now, the facts of Vulo has been described before. In fact, we've linked up the videos we've done, but essentially, Miss Vulo, who was the Secretary of the Department of Financial Services, basically regulating banks, essentially went around and threatened and coerced financial institutions to quit doing business with the NRA and other similar organizations. It was almost a mafia-style shakedown, and of course, if they had some types of investigations going on at their particular financial institutions, just quitting to do business with pro-Second Amendment groups suddenly seemed to clear up some of those investigations. The NRA successfully sued the state of New York on this, claiming violations of First Amendment rights. The Supreme Court has found unanimously that the NRA has a valid claim there. What's happened now is they've tried to individually sue Ms. Vulo personally, stating that she individually had violated individuals' rights to free speech as well as equal protection under the law. But the problem, of course, is this. The Second Circuit Court of Appeals has found, as discussed more fully below, we conclude again that Vulo is entitled to qualified immunity, for the law was not clearly established that the conduct alleged here, regulatory action directed at the non-expressive conduct of third parties, constituted coercion or retaliation violative of the First Amendment. Accordingly, we reverse the district court's denial of Vulo's motion to dismiss on the basis of qualified immunity, and we remand for the district court to enter a judgment dismissing the remaining claims. Now, if you recall, when we take a look again at the definition of qualified immunity, we can only pierce through that immunity and sue the individual so long as we can establish that their conduct violates clearly established statutory or constitutional rights and there is no existing case law directly on point. Which means that for individuals who are claiming qualified immunity, ignorance actually becomes a defense because they get to say, I didn't realize I was violating constitutional rights. It wasn't apparent to me. There's It's not like I violated the letter of the law. It's not like there was a case out there that said I was doing anything wrong. And so because I had no knowledge, whether they should have or otherwise is irrelevant, that allows the courts to let these people get off the hook. That's how qualified immunity works. And you see, here's the thing. Even though the United States Supreme Court has found that the NRA made a valid First Amendment claim against Vullo and the state of New York, when it comes to her individually, oh, no. See, this is where the Second Circuit comes down. Vullo contends on remand that she is entitled to qualified immunity for her challenged conduct, notwithstanding the Supreme Court's holding that the NRA plausibly alleged a First Amendment violation. We agree and proceed in two steps. First, although the Supreme Court has held the NRA plausibly alleged a First Amendment claim, we take up Justice Jackson's invitation to consider separately the NRA's two distinct First Amendment theories, censorship and retaliation. And listen, when you are taking up anything that Justice Jackson suggests, you know you are going in the wrong direction. And then after going through pages and pages of analysis as to why this wasn't retaliatory behavior or why this was not coercive behavior on her individually, but all based in just being ignorant about individuals' constitutional rights and the effects of her actions on that. I'm dead serious, and we're going to link it all up down below. You don't have to take my word for it. You can geek out on it for yourself. But then it allows the Second Circuit and any other court that just wants to let these people walk, okay, it allows them to make rulings like this. Qualified immunity protects all but the plainly incompetent or those who knowingly violate the law, and it generally attaches to conduct that does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. And then they continue, in this circuit, officials are generally entitled to qualified immunity for their official acts unless the plaintiffs plead facts showing, 1, that the official violated a statutory or constitutional right, and 2, that the right was clearly established at the time of the challenged conduct. And where the Second Circuit is coming down is that you cannot establish the second element here, because Vullo can claim that she was not aware that the right had been clearly established at the time of the challenged conduct. And again, you want to know how they can dumb it down for everyone? This is what the Second Circuit gets to do thanks to the doctrine of qualified immunity. In other words, a right alleged to have been violated is clearly established only if it is sufficiently clear to every reasonable official that the challenged conduct in the specific context of the case violates that right. In determining if a right is clearly established, this court looks to whether 1, it was defined with reasonable clarity, 2, the Supreme Court or the Second Circuit has confirmed the existence of the right, and 3, a reasonable defendant would have understood that his conduct was unlawful. And again, they can know that there's a clearly established First Amendment right at play, but they could just play ignorant to the fact that their conduct was infringing upon it. And if they can plead that with a straight face, at that point, qualified immunity allows courts like the Second Circuit to do the following. Vullo is entitled to qualified immunity on the NRA's impermissible coercion and retaliation claims because the First Amendment rights at issue were not clearly established at the time of the challenged conduct. Reasonable officials in Vullo's position would not have known for certain, based on the cases cited above, that her conduct crossed the line from forceful but permissible persuasion to impermissible coercion and retaliation. And again, just ignorance to the consequences of one's actions allows an elected official to escape civil liability through qualified immunity. Now, I want you to understand that there are some good things that come with qualified immunity. I have given you the ugly underbelly of qualified immunity. But I can assure you that if we could sue politicians for everything that they did while they were in office, one only need to consider what the current president, when he was president number 45, would have gone through for all of the acts he had as president in his first term. So understand that there are some significant benefits, and there's a reason why we as a constitutional republic establish qualified immunity to ensure that we don't have a chilling effect on our ability to govern. But at the end of the day, y'all want to know why it is that you can't sue some of those legislators who you know are absolutely and intentionally violating your Second Amendment rights and get anywhere with that lawsuit? Well, once again, it's through the doctrine of qualified immunity, as evidenced right here in the case of National Rifle Association v. Vullo. Listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, cool. You click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.